All right, hi everybody. Welcome back to Attorney Steve Vondran. Welcome to another exciting video today. We're talking about YouTubers, video platforms, and DMCA takedown notices. All right, what happens when somebody's infringing your content on YouTube? It all starts with a takedown notice. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, guys, we're back. All right, so when somebody's infringing your content on a social media platform, we're talking about videos today, but it applies really to any sort of copyrighted content. The DMCA stands for the Digital Millennium Copyright Act. So we're talking about copyright here, okay? Whenever you have a dispute, it usually goes this 1, 2, 3 process. Not very tough. It all starts with a takedown notice to the service provider. So say we're talking about YouTube or Vimeo or TikTok, videos on TikTok and whatnot. You start with a takedown notice. Hey, this guy's using my copyrighted content. They can't do that. They cannot do that. So you send a notice. It has the link where it is. It has a good faith belief that they are infringing on your content. And so you send this to the service provider, and then the next step, the original person who posted the video will be notified by YouTube and whatnot. They will be notified of the takedown notice, and they will have an opportunity to do nothing and get a strike, or sometimes you see multiple strikes. Nowadays you see parties conspiring, coming together to try to take down a channel. You submit a DMCA, you submit a DMCA. We'll get 3 of them, and they will strike out, and the channel will be taken down.
Strike 3, he's out.
Oh God, this is strike 3.
All right, so you can do nothing or you can fight back, but only if you're right, because what you're saying is under penalty of perjury, the next step here is for the person who originally posted the video to file what's called a counter notice, also known as a counter notification. All right, now there's no set time frame of when you have to do this, but you need to make careful to do it right, okay? Many times you're talking about they're mistaken as to the video, or many times we're talking about fair use. It's a fair use. All I used was 5 seconds. I posted a video, all I used was 5 seconds, and I did commentary, transformation. I changed the colors, I changed the storyline, I made a parody, just all kinds of things. So if you feel that you have valid fair use rights, then you can come here and fill out your own counter notice. That's going to go back to this party, okay? Now, again, I need to be careful when you're doing counter notices. It's very important. Although technically the service providers are supposed to forward your counter notice to the original party, forward it so they can review it, we have seen cases, for example, in YouTube, where the YouTube may say, we don't think you have the rights, and they will not forward your counter notification. So this really leaves you in a bad spot because your video is going to be taken down. You're not going to have a chance to get it back up. So it's ultra important if you do not use boilerplate. Do not say, my video is fair use. You need to go through the 4-factor test. I have it on other videos. Attorney Steve 4-factor test, okay, for copyright fair use, 4-factor test. Not going to go through it here, but if you do boilerplate, maybe it's 3 different videos and you do the same boilerplate for 3 different videos, YouTube may look at these and say, you're not being serious. You're not going into detail as to why this one is and this one isn't and this. So you need to be very specific when talking about your fair use rights. Many times it's fair use, okay? Sometimes you may have a license. Sometimes it may be public domain. Sometimes this may not be their copyrighted content at all. So there's different things that can happen. So you get your counter notice. That comes back to the original party. Now, the parties can get together and negotiate a deal. Say, hey, well, why don't you license a video? Well, what do you want to charge for? Well, why don't you use my videos and I'll use your videos, and we can get a little buzz going online as we're using each other's videos, oftentimes commenting or making fun of each other. Sometimes that creates a little synergy online and boosts both channels, okay? So anyway, get your counter notice right, get what you need to do. This is under penalty of perjury. This is under penalty of perjury. You're saying that you have these good faith belief that this is infringing, or good faith belief that it is a mistake. This is not infringing because of fair use. So in most cases, you're going to see YouTube will forward the counter notice, and that triggers the final step of the 1, 2, 3 process, the lawsuit. So if the original party that filed the takedown gets the counter notice and says, you know what, this person's wrong and I'm going to sue them. Because one thing you're going to find in these counter notices is you're going to be consenting to jurisdiction many times in the Northern District of California, where Vondran Legal can represent you in court, okay? But your next one is you have 10 to 14 days. I would suggest you file it as soon as possible. You're going to file a lawsuit, okay? When I say lawsuit, I put that there specifically. No CCB. What is a CCB? Copyright Claims Board. This is not an action. This is a claims board. This is not a legal lawsuit. The key here, and I saw somebody doing this, and somehow they were getting away with it, but I think all that's going to come to a stop. But anyway, you have 10 to 14 days, very strict timeline. File the federal copyright infringement action by this party. They're going to say, I don't believe you, you're infringing. I'm going to file the lawsuit. Okay. The lawsuit's filed. You notify YouTube, hey, we're filing a lawsuit. That content will stay down. That content will stay down, okay? And I put here 17 USC, United States Code 512G2C, as in, there's a call now. C as in cucumber, right? So in this section, it says you must file an action to restrain, an action to restrain. In the Copyright Claims Board, you cannot get an injunction. You cannot get that sort of relief because it's a claims board. It's not a real court. So this makes it clear that you need to file the lawsuit. This party files the lawsuit. This party gets named. Typically, many times you're going to be in Northern District of California, and the parties duke it out over fair use or whatever other issues. Lots of times you see, along with these claims, you see 512F, as in Frankfurter. Those are your bad faith takedown and your bad faith counter notice. You have to have good faith when filing these. In fact, when you're filing a takedown notice, you need to make sure you're considering fair use. You need to at least go through the 4 factors in your mind before you issue the takedown, okay? So that's a general how it goes in the DMCA land. A lot of creator disputes. I call them creator wars. So Vondran Legal, we're a leader in the field. We handle a lot of these cases, a lot of fair use opinions, federal court litigation, but this is a general legal overview of the DMCA 1, 2, 3 DMCA process. All right, if you need help, give us a call. You can find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Gotta run. Good to see you guys again. Have a great day. Bye now.